Good morning, everybody. A very warm welcome to our second construction and engineering webinar of 2023, which is our summer update. My name is Stefan Harris-Wright. I'm a partner in the construction and engineering team at Birketts Solicitors. If we could have the next slide, please. So the theme for this morning's session is up on the slide for you there, and it's effective management of payments, claims and delays in an uncertain market. So as construction lawyers, we are finding, unfortunately, an increasing number of claims are coming to us for advice in those situations, and whether that's due to sort of general market conditions or pressures on supply chain, availability of materials, or whatever it might be. So we thought that it would be useful to summarize some of the issues that we're seeing arising in these scenarios, and hopefully provide you with some useful kind of hints and tips on how to avoid claims, but also help protect yourselves in a project scenario, in a claim situation. If we could have the next slide, please. So just briefly, hopefully most of you will have heard of us before, but just in case you haven't, there's some sort of information at a glance up there on the slide if you want to review it afterwards. But in summary, we at Birketts are a full service top 50 law firm. We've got 6 offices across the UK, in the east of England and London and Kent. And as part of our overall organisation, we've got a specialist team of construction and engineering lawyers who advise on both transactional and contentious construction matters. If we could have the next slide, please. So I wanted to take the opportunity now to introduce our speakers. So aside from me as your chair, we've got Katrina Bretten, who's a senior associate in the construction team. We've also got a guest speaker for you today, Richard Devoy. Richard is a director at the construction consultancy planning manager, and he's an accredited expert witness, and he specialises in construction programming and delay analysis. And we've also got another colleague, John Fawcett. John's a senior associate in the construction team, and he specialises in advising on construction disputes. So welcome to all of our panel. If we could have the next slide. So just to briefly summarise what it is in terms of the content for this morning's session, Katrina is going to talk about payment in construction projects. She's going to have a particular focus on the statutory scheme for payment under the Construction Act, as it's known, and also how that's sort of mirrored and reflected in 2 very popular industry standard forms of contract, JCT, D&B, and the NEC form. Richard, our guest speaker, is going to give us a really interesting and useful introduction to some key concepts and principles in relation to delay analysis in construction claims. And then finally, John's going to give us an update on some recent, interesting and significant construction and engineering cases. And then at the end of the session, there'll be an opportunity, some time for a Q&A. We'll bring all the panel back and you'll have a chance to put your questions to our panel through the questions function in the GoToWebinar portal. Just to say about that, the questions come through to us as panelists and the chair, and not to the whole group, not to all delegates, so you will remain anonymous, so please don't be shy. There's been a good number of you have sent some questions in advance, so many thanks for those. We've had a fantastic turnout for this session, so I can't promise we'll have time for all of the questions, but we'll certainly do our best. One other thing to mention is that we've got some polls during the course of the session, so the speakers will introduce those at various points, a chance to vote on some multiple choice scenarios and add some extra kind of colour to the session, so please do participate in those as well. And then we'll look to draw proceedings to a close by midday. Finally, on some housekeeping, the session is being recorded and will be circulated as a video to delegates within a few days, and we'll also include a copy of the slides. If we could have the next slide, please. So without further ado, I will hand you over to Katrina for the first part of the session. Thank you.
Thank you, Stefan. Good morning, everyone. So as Steph said, I'm going to be talking about payment in construction contracts. Can I have the next slide, please? So by the 1990s, the government had come to recognise that construction was somewhat of a broken industry. It took on board recommendations from key industry reports, which ultimately led to the creation of two new pieces of legislation, the catchily titled Housing Grants Construction and Regeneration Act, which we refer to as the Construction Act, and the Scheme for Construction Contracts, which we refer to as the Scheme, both of which came into force on the 1st of May 2008. The legislation applied to construction contracts which were defined to include any contract for construction works or services at any level of the supply chain, aside from a few exceptions such as contracts relating to PFI, power stations and supply-only arrangements. Concentrating on payment, the legislation requires that construction contracts include an adequate mechanism for determining what payments become due and when. This is generally known as the due date. Now, bizarrely, rather than being a date by which payments need to be paid, the due date is actually used as a mechanism for determining that final date for payment. More on that later. The legislation also introduced concepts of payment notices, which are notices to be served by the paying party, allowing them to value the contractor's application for payment. It referred to the concepts of withholding notices. Some of you might remember those. They were notices to be served by the paying party, allowing them to make deductions from the sum which had been certified. It gave payee parties the right to serve a 7-day notice of intention to suspend their performance of works or services in circumstances where they hadn't been paid. The legislation also included a ban on pay when paid clauses other than an insolvency situation. And finally, a key feature of the Act and the scheme were that if the construction contract didn't comply with these key requirements, then those key requirements would effectively be implied into the construction contracts, meaning it wasn't possible to contract out of the Act or the scheme. Next slide, please. So after around 10 years of the original Act, the government decided to make some changes in an attempt to address some shortcomings which had subsequently been identified. For example, under the original Act and scheme, there were no consequences for a failure by the paying party to serve either a withholding notice or a payment notice. This resulted in essentially two new pieces of legislation, the New Construction Act and an update to the scheme. Now, the new Act introduced the concept of default payment notices, effectively meaning that the contractor's application for payment would amount to the default payment notice in circumstances where the paying party failed to issue their payment notice, and withholding notices were instead replaced by pay less notices. Next slide, please. If we start off by looking at the basics in relation to the Act and the scheme, there are a number of potential scenarios. The Construction Act says that construction contracts have to provide an adequate mechanism for determining what payments become due and when. This includes certainty of the due date. I mentioned earlier that bizarrely, that's not the date by which a sum has to be paid, but it is a mechanism used in determining that final date for payment. There's also then an obligation on the paying party to serve a payment notice within 5 days from the due date. Now, that's a statutory period which is fixed and cannot be amended. There then has to be certainty of the final date for payment and an ability for the paying party to issue a pay less notice. Critically, if these minimum requirements are not met, then the relevant provisions of the scheme will be implied into the construction contract to plug those contractual deficiencies. And finally, on this slide, the wording of the legislation is that the payment mechanism has to be adequate, but unfortunately it doesn't have to be fair. So, for example, those 180-day main contracted payment terms that we've all heard about, whilst certainly frowned upon, they're unfortunately not unlawful. Next slide, please. Okay, so looking then at payment notices, what are the requirements? In terms of timing, a payment notice must be served no later than 5 days after the due date, and this is a fixed period. As to the content, the payment notice must specify the sum that's due on the due date and also the basis upon which that sum has been calculated. Now, this is particularly important in circumstances where the amount certified is less than the amount applied for in the contractor's application for payment. It's not sufficient to simply state how much you intend to pay, but you also need to show your workings out. If the notice is served out of time or with insufficient detail, then ultimately it will amount to an invalid payment notice, the consequences of which can be severe, as I'll come on to explain shortly. Next slide, please. What about pay less notices? If you've not come across them before, a pay less notice is a notice issued by the paying party, either where they failed to serve a valid payment notice either in time or at all, effectively giving them a second bite at the cherry to value the contractor's application for payment. Alternatively, they can be used to make an adjustment where something has become apparent after issuing the payment notice. And finally, they can also allow the paying party to make deductions which were not appropriate to deal with in the payment notice itself, such as, for example, to issue, in respect of liquidated damages claims, for example. Now, much like payment notices, a pay less notice which is served either out of time or with insufficient detail will amount to an invalid pay less notice. Effectively, this means that the sum applied for becomes the sum which is due. This was probably the most important change introduced by the new Construction Act, designed to make sure that there were meaningful consequences for failures by the paying party to serve either payment notices or pay less notices. Whilst it is possible for employers to make recoveries in subsequent payment cycles, the client will still have paid out money which ultimately wasn't due to the contractor at that time. Also, if this happens either at or near to practical completion, then there may not be sufficient balance left of the contract sum for the employer to make that recovery. The client is left in the unenviable position of then having to recover monies paid out to the contractor. This can also present an insolvency risk if the contractor goes insolvent before the employer has been able to make that recovery. The overpayment would then amount to an irrecoverable loss for the client. Next slide, please. Okay, the consequences of failure, just to summarise. If there's no valid payment notice and no valid pay less notice, then as I've said, the sum applied for becomes the sum which is due. It can be corrected, but there is an insolvency risk if that correction doesn't happen before the contractor goes bust. Next slide, please. This is just a simple graphic to illustrate the timescale set out in the legislation. It's in effect the minimum requirements that are implied by statute. And as you can see, the timescale is very short, only 17 days from the due date for payment to the final date for payment. It's therefore really important for employers to ensure that their construction contracts are compliant. Next slide, please. And again, sorry. Moving on then from these minimum standards, all industry standard forms have been drafted to fit with these requirements, although some forms have subtle but significant differences which are worth exploring. To illustrate this, as Stefan mentioned, we thought we'd look at the JCT and NEC forms of contract to highlight how the legislation has been applied into those key standard form contracts. Firstly, then looking at the JCT contract, one key thing to mention is a small but important difference between the JCT design and build contract as compared to the standard build contract. And that is that the payment cycle under the D&B form is application driven, whereas in the standard form contract, it's valuation driven. Essentially, this means that under a D&B form contract, the employer's agent would still be required to respond to a payment application, even if it arrives later than the date specified in the contract. And this is because the D&B form works on the basis that the due date for payment is calculated as being the later of the date specified in the contract or the date on which the application is actually received. Now, a term specific to the JCT form of contract is that of the interim valuation date. It is effectively the date by which the contractor is required to submit his payment application. And that's usually the same date in each month in contracts which have a monthly payment valuation cycle. The due date is then calculated as being 7 days from that interim valuation date. So as you can see, the payment cycle under JCT standard form contracts is already going to be a little longer than under the scheme by the introduction of this interim valuation date. The payment notice must still be served no later than 5 days after the due date for payment. That's the fixed period by statute, and it cannot be amended. But the final date for payment is 14 days after the due date. There is flexibility as to calculation of the final date for payment, so that's often one amendment that we commonly see. Any pay less notice needs to be served no later than 5 days before the final date for payment, although again, there is flexibility in this. It needs to be not more than 7 and no less than 1 day before the final date for payment. So that's often commonly pushed back to not less than 1 day before the final date for payment, just to give the employer's agent a little bit more time. Ultimately, though, if there's no payment notice or pay less notice, then the sum applied for becomes the sum which is due. Next slide, please. So here we just have a graphic to illustrate the mechanism that I've just described. As you can see, at 21 days, it's slightly longer than the payment cycle under the scheme, and this is due to the introduction of that interim valuation date. The green graphic at the bottom just illustrates the point about the payment cycle being application driven. And so where the contractor serves his application for payment 4 days late, then the employer's agent will still be required to respond to that application for payment. Next slide, please. So this diagram just illustrates the payment cycle under the JCT standard form contract. I won't dwell on it too long because the timescales are exactly the same as that under the design and build form contract. The only difference is that the application process here is valuation driven. So if the contractor doesn't submit his application for payment on time, the employer's agent will not be required to respond to it, and it will be an invalid application. Next slide, please. And again, thank you. Moving on then, we just wanted to touch briefly on payment under the NEC4 ECC form of contract, as we're conscious that some of you will no doubt use that from time to time. In summary, the timescales are essentially the same as that under the JCT forms of contracts, albeit that the terminology is different. So you'll no doubt be aware reference to employer's agent is instead referred to as the project manager, and the interim valuation date is known as the assessment date under the NEC4 ECC contract. Next slide, please. Finally, then, we've included a diagram to illustrate the payment cycle. As I've said, other than terminology, it mirrors the approach taken by the JCT form of contract, but specifically the standard build form contract. So the payment cycle here is also valuation driven, meaning that the project manager isn't required to respond to an application for payment which is served late, and the dates don't push back. Next slide, please. Thank you. So we're on to question time. A retail client is procuring the refurbishment of an out-of-town shopping centre. The client has appointed the main contractor pursuant to an unamended JCT design and build contract. Works appear to be progressing well, and the contractor submits his application for payment in the sum of 1.25 million. The employer's agent issues a payment notice certifying the sum applied for is due. A week before the final date for payment, the employer's agent discovers that elements of the work are defective and require correcting. The employer's agent returns to office and issues a pay less notice 1 day before the final date for payment, stating an intention to withhold the sum of 350,000. The employer pays the balance of 900,000 on the final date for payment. The contractor decides to issue a speculative adjudication to recover the 350,000. The question is, would the contractor be successful on that adjudication? What do we think? Okay, well, the key here was the timing of the pay less notice. Whilst, as I've said, it is possible to push this date back from the 7-day statutory maximum to not less than 1 day before the final date for payment, the unamended JCT D&B contract provides that any pay less notice must be served not less than 5 days before the final date for payment. As such, for the purposes of this contract, the pay less notice was served out of time and so was invalid. The contractor would therefore be successful on that smash and grab, effectively adjudication. Next slide, please. Can we move to, thank you. Okay, so finally, just some points to note. I won't steal John's thunder with his case law update, but it would be remiss not to mention a couple of key cases when talking about payment in construction contracts. The first case, Balfour Beatty and Grove Developments, highlights the importance of allowing for additional payment dates in your payment schedule, where in circumstances where the target completion date is not met. So in this case, the parties had agreed a very detailed payment schedule, which had payment dates linked to the target completion date. However, practical completion was delayed by over a year with no additional dates specified. And the courts held that in those circumstances, the contractor was not entitled to any further interim application for payment. Moving on then, the case of Rochford Construction and Killen highlights that whilst VAT invoices will no doubt be an important internal requirement for processing payments, they should not be required as a provision for calculating the final date for payment. Instead, the judge held that the final date for payment must be calculated from the due date itself and not some other event or mechanism in the contract, such as the provision of a valid VAT invoice. More recently, there have been cases regarding the timing of applications for payment. The first case of A&B Building Solutions versus J&B Hopkins confirms that where there is conflict between the payment schedule and the contract provisions, the two documents need to be read together. So in those circumstances, the judge held that a payment application which was served on a Monday, 1 day later than the date specified in the payment schedule, was not so late as to render it invalid. Finally, the decision in Elements Europe versus FK Building Limited clarifies that when calculating days for the purposes of construction contracts, we mean whole calendar days and not just business hour days. So here, a payment application which was served at just after 10 p.m. was still a valid application for payment. And so by FK Building failing to respond to that, it rendered the whole amount due and payable to the contractor. Thank you. That's all from me on payment. I'm now going to hand over to Richard Devoy.
Good morning, everybody. Thank you, Katrina, and thank you, Steph, for the introduction. So what am I going to talk to you about today? Today we're going to go through some guiding principles for delay analysis, some typical terminology and definitions that you may hear within the delay analysis arena. We're going to look at and go through an appreciation of some of the types and methods of analysis that are commonly used. This will give us an overview of the type of records and documents that are often requested or required to perform these methods of delay analysis. And then briefly, we're going to have a look at a typical example of an analysis in operation. If we go to the next slide, please. So within the world or the arena of delay analysis, we have a very important document that is the Society of Construction Law Delay and Disruption Protocol. It's been around for a few years. You can see here it's in its 2nd edition, dated February 2017, and it's referred to very often as a very sound starting point for any particular type of delay analysis itself. Two main types of analysis you can see on the slide in front of you: cause and effect and cause. So what do we mean when we say cause and effect, or effect and cause, and what are the differences between the two approaches? So in the example of cause and effect, what we're essentially doing here is we have an event or a cause that has occurred. This is often occurring at the time when we're looking to see what impacts that may have, that impact being the effect, and what we're seeking to understand is there likely to be an effect from an event or a cause that has occurred. You may hear people say the word contemporaneous. Contemporaneous means it's at the time that it's occurring, in a very brief definition. Prospective I've got in brackets there, we'll come on to slightly later on. But the general principle here, referring back to the protocol, is that it's best not to wait and see, i.e. don't wait and see if there is an effect of a particular cause. It may be an instruction that you have received from the employer that may be having an impact on the critical path of the works. It can be used as a tool to give advice to that employer on the notices or the notice functions within the contract of likely delay that may run or resonate from such an instruction. And then conversely, effect and cause is largely the exact opposite of what a cause and effect would do. With an effect and cause, what you have is a more fact-based approach. So typically the effect would already be known. It would already have manifested itself in something like a delay. You would be able to quantify that delay, have a look to establish whether it was causing an effect on the critical path, and thereafter you would seek to determine what the likely cause of that effect was. This is more aligned with a fact-based approach, or much more aligned with a fact-based approach when you are trying to establish causation for a known delay. Again, reference back to the protocol. Core principle here is core principle 11. Next slide, please. Thank you. So I talked briefly about the terms prospective and retrospective. Prospective, as I've said in the previous slide, what we're doing prospective is a look to the future. So typically it's a hypothetical approach. We have a cause and we are seeking to understand a likely impact of a cause. We are looking to the future to establish what that might be, which will allow us to both plan, monitor, and give advice to others within the contract and the parties to the contract as to what effects that there may be on the horizon. Retrospective is looking back, so that it is historical. It is looking back at what's actually happened, so it would be a known period, and then from that known period we are seeking to identify actual delay on the critical path rather than a hypothetical impact that may be apparent on the critical path in the future. Retrospective is looking at the facts. This delay has occurred. It is a critical delay. What is the cause? Next slide, please. So within the protocol, what we have in front of us here are the typical methods of analysis, certainly the more common used methods of analysis within the delay analysis arena. And you can see on this graphic that we have the words prospectively, contemporaneously, retrospectively, cause and effect and cause across the analysis type, the method of determining critical path, and the method of determining the likely delay impact. So all of these terms now hopefully you have a general understanding of. And what this would do here is this would give us a function of determining what method of analysis would be best suited to a typical scenario that has occurred. If we are either providing advice or we're undertaking a method of analysis, we would be looking at this to pull together the most effective use of the analysis required for what's in front of us. Some of the things you can see in the very far right column of what particular methods of analysis require. We're talking about programs. Obviously, if we're looking at time-related delay, there is baseline program. By baseline program, I mean the original program, usually a point of contract, that set out how the contractor was going to get from its start to finish to deliver the whole of the scope of the contract works. Different methods of analysis, some will rely on reschedule calculations being undertaken through the software programs that these program files are drawn up in. With these program files, it is important that we have a level of robustness to undertake the calculations within the software. Some of the other methods of analysis, such as the as planned versus as built analysis, which is the fourth analysis on this graphic, doesn't have to have a reschedule capability. It is a more static view, i.e. you are drawing out from historical view retrospectively. As I said earlier, you will know what the general period of delay is, and you are then looking to establish the actual critical path from all of that as-built data to opine on where the cause of that delay has occurred. I think one thing to touch on before we move on to the next slide is the concept right back to the start of this, is that some of them are important for future, i.e. looking ahead as what the likely impact may be. Some of these analysis methods are more fact-based and preferred where they are time distant, i.e. a period of time has elapsed between a cause occurring and the delay itself is trying to be understood. Next slide, please. So typical records that would be required to perform a delay analysis. I've obviously put on here, remember, records. An analysis is very reliant on the standard of records that are available. Typical records that we would request when we are undertaking methods of analysis, certainly if it's a historical retrospective view, would obviously be contract, diaries and progress reports. So we're able to put together an as-built program. By as-built, just very briefly, I mean the actual progress of the works measured against what the original intention was. And then we would be seeking to look at giving opinion on the critical path, where that actually was, where the critical path went through, looking if there are areas of delay to that critical path, and then using things like the instructions, variations and changes logs, correspondence, emails and letters to try and establish what the cause of that delay was that is measured through the retrospective analysis. Right, at this point, we're going to do another quick poll, another quick question. If we can have the next slide with the question on. So the question here, contractor receives an instruction from the employer in week 2 of their contract program. Contractor believes that the instruction will likely have an impact on the progress of the works and completion, and is seeking to model the likely effect of the event at the time it is occurring by employing a method of delay analysis. So in that scenario, would that be a prospective method or a retrospective method of analysis? So the key words in that question are obviously likely to. Wonderful. The answer is prospective. Prospective in that it is likely to have an impact, therefore the actual effect of the instruction isn't yet known, but what we're trying to determine is the likely impact, so we can therefore make sure we've got relevant notices in place and be giving the advice necessary to establish the importance of where the project completion or the critical path is going with the program of work. Next slide, please. So, methods of delay analysis and impacted as planned position. So here we have a simple graphic, a cause and effect method of analysis determining critical path impact prospectively. This is the first method of analysis that we have on that table that was on one of the previous slides. You can see that we've got a very simple sequence of events, lines 1 through 8 here, running through 6 activities, all of which are very, very kindly finish to start relationships, i.e. activity A starts and finishes before activity B starts, and so on and so forth through our milestones start to completion. So this would essentially be our baseline program, and we can see that the logic is the network logic is completed, and we have the black arrows completing our logic from the start milestone through each of the activities in the finish to start relationship, driving a completion 8 weeks after the commencement. So what we would then do is, if in the event described in the quick poll that everybody just took part in, if we had an event that occurred, if you can raise the next slide, please. And this event occurred in week 2, as is drawn on the graphic through lines 9 and 10, describing this simply as delay event 1. In this scenario, the contractor might say that in week 2, the instruction that's received to solve or get a solution to that instruction is going to take us 3 weeks. Forecast, we think it's going to take 3 weeks. And the likely impact of that instruction and until resolution is achieved is going to constrain the start of activity C in this particular scenario. So that gets plotted into the program, into our program within the software. The network logic gets updated, and you can see there the link between line 10 and line 14. That network logic is updated to model the impact of the delay event on the commencement of activity C. And the reschedule function within the software will move those activities that are succeeding that logic through the delay event to its revised position in this model of the event itself. Now, this can be done for a single event. It can be done for a series or a number of events to establish what the impact of each of these events may have on the program and therefore the critical path. What we can see from this is that at line 20, the impact of the delay event 1 is likely to result in a critical delay of circa 2.5 weeks, 2 weeks and 2 days, to the completion of this particular sequence of work. And we would be able to use this to put our notices in place, give some advice to the parties in the contract that the event itself, or this delay event that has occurred, it's an instruction, is likely to delay the course of the works without further mitigation that may be employed to try and recover that lost time. Next slide, please. So, in summary, what we've been through are types of analysis and methods of analysis that can be used. We've been through some key terminology and some guiding principles that are necessary. Main guiding principle I would say to you is the difference between retrospective and prospective, i.e. if it's occurring at the time, do not wait and see, perform these prospective methods of analysis. If it's something that needs to be done retrospectively, fact-based, they typically are a longer method of analysis. There is more to them because it is seeking to determine something that has already occurred as opposed to a hypothetical view to the future. And something else that's very important in terms of consideration, contract must obviously follow what the contract says in terms of analysis. What is required? Are there specific types the contract says you must use? And the records that are available. It is very important that there are records kept that would allow these methods of analysis to be undertaken should you find yourselves in a need to be performing them or coming to experts like myself to assist with that form of analysis. Next slide, please. A couple of useful links for you on here. I've talked about the protocol itself. These slides will be made available to you, and these hyperlinks will work. Simple Google search will also provide you the same route. But this document is freely available to download. It's not a short document; it's fairly lengthy, but there are some very good guiding principles that you can pick out of that as a document for a basis to understand and view the typical world of delay analysis. The second link I've got here for you, I talked very briefly about robustness of programs and the requirement to have a robust program if you are performing certain methods of analysis that rely on software reschedule calculations. This document is a fairly recent document. CIIB Planning Protocol 2021 is also freely available to download. But this document is aligned at trying to establish a protocol and a procedure for ensuring that there are robust levels of programs in place for construction projects. It talks through metrics and stress tests between the different types of projects, whether they are major projects or standard projects. And again, a very good document to be aware of, to look at if you are building programs to ensure they have a level of robustness. Often with these, certainly with some of the software available, programming software available, they now have some of these tools built in, so you are able to stress test the programs and get a result as to the level of robustness that these programs have. Next slide. Thank you very much. Thank you for listening. I am now going to pass you over to John Fawcett.
Thank you, Richard. Much appreciated for the handover. We've got a few cases to get through today, so we'll go at a bit of a gallop. Thankfully, my colleague Katrina has already touched on one, so we can hopefully short that one down. Let's start, though, with a bit of a poll. If we can pop that up on screen. Court cases are taking a while at the moment, but how long do we think they're actually taking? Looking at the larger scale cases, so fast track and multi-track cases, which are anything up to the billions. I'm glad to see that there are some cynical minds out there. I'm afraid the majority here are right. We are looking at 80 weeks at the moment to reach trial. That is obviously a very long period of time for a case to get to trial, and it comes with considerable downsides, but it does sometimes open up some scope for negotiation and settlement as well. But it's worth bearing in mind when you're thinking about whether to take a case to adjudication or through the court process. Also potentially worth bearing in mind when you're considering whether to bring an arbitration clause into your contracts in the start. Talking about the court process as well, we'll see here next we're talking about the intermediate track. The court has decided to bring in a new track. Tracks are what the court uses to segment cases into differing values so that they can apply different rules. Here the court's bringing in an intermediate track, which will include fixed recoverable costs, which means you will have a certain amount of costs that you can recover, and whether or not you incur more than that, that is all you're going to get through. So we will have to bear that in mind when it comes to the tactics of when to issue and whether or not claims are worth it. Particularly, that's going to come into force on the 1st of October this year. So if you've got claims which you're currently umming and ahhing about, you probably need to take advice on them sooner rather than later, so that tactical considerations can be taken into consideration for the question of issuing before or after the 1st of October. The third point on this slide is a very current one. AI, it's everywhere, isn't it? And I'm afraid it's reached judges as well. We have had reports of judges using ChatGPT to help prepare their judgments. Fortunately, in most cases, they seem to be using it just to help them to summarize cases and the like. But it's certainly something to look out for, given the propensity for such software to make things up. Next slide, please. So on to our first actual case of the update. This is a case which is a Scots case, which means it's not binding on England and Wales, but it's worth noting because Scottish courts do take a very similar approach to the enforcement of adjudication. Here, the party ordered to pay by the adjudication decision sought to resist enforcement on the basis that the adjudicator had erred from the principles of natural justice, in that he'd considered, or he'd made a decision which was based on some elements which were not put to him by the parties. The paying party wanted to try to avoid paying, but the court wasn't really having any of it. Ultimately, the court determined that the judge had reached a decision which wasn't necessarily subject to express representations by the parties, but because that was only part of the answer to the wider question, part of the route to getting there, the court determined that there was no breach of natural justice. Basically, what this is to show is that the court will be very reluctant to refuse to enforce adjudications. The court, whether English or Scottish, is very supportive of adjudication, and resisting adjudication is often a dangerous business. Next slide, please. So, having just said that resisting adjudication can be a dangerous business, this is a successful resistance. Here, the case turned on whether or not the adjudication had been brought outside of the limitation time. The limitation is set by the Limitation Act, and this was a simple contract, so the period was 6 years. The adjudication had been brought 8 years after the contract had been completed. The adjudicator allowed the claim, but on enforcement, the judge was not persuaded and refused to enforce on the basis there was an absolute bar because of the limitation point, and also determining that the limitation period also applied to the right to bring an adjudication, therefore meaning that the adjudication itself was invalid. There was a slightly interesting point on the time that those rights accrue. The judge in this case went a bit off track and determined that he would take a different approach to the standard position, which is set down in Hurst and Dunmar. It wasn't something we think is going to be persuasive generally, so I won't dwell on it, but it's worth noting that even cases that we think are likely to be binding can be worked around. Next slide, please. So another enforcement case. They seem to be popular at the moment. This was a case where FK had sought to enforce a decision and ISG was looking to set off other cases so that they could pay less. The court went through the previous authorities on the position and determined that FK would not be successful. ISG would not be successful in that. If we move on to the next slide, that sets out the tests that ISG failed to reach. There's 4 stages to go through. We've got an article out on this, so if you want to look at them in any detail, go and have a look at that. But broadly, just to say, you need to make sure you've got a valid decision. Then the decision must be enforceable, capable of being enforced, and then the court may give effect to both decisions if proceedings have been brought by both parties. Here that wasn't met, but it's worth noting, if you want to try and use this kind of argument, you're going to need to get your ducks in a row, issue proceedings, and be in a position of equality with the opponent. You can't just rely on it without having taken some procedural steps as well. Next case, please. Okay, so this was an insurance case that you may have seen coming through the courts previously. This was a case concerning the redevelopment of Twickenham, and it is interesting because it really is an overlooked issue, and the judge, even in this case, suggested that it was surprising that the parties had not given more consideration to the insurance provisions of the standard form contract, given the scale of the amendments to the remainder of the contract. But in essence, here, the question was whether or not the insurer under a joint aims party could bring a claim as a subrogated claim against one of the named parties to that policy. Here, the insurance company was able to do that insofar as those claims were not ones which were excluded under the terms of the contract. Terms of the contract only excluded claims which related to the very specific elements of damage to the works on site. So there was a cable that was damaged to the tune of, I think, about 1.1 million. That claim could not be pursued, but the claim for remedial works to the defective works which had in turn damaged that cable could be pursued because that was not within the scope of the insurance. It is important, therefore, to note that if you want to make sure that the insurance, the joint names insurance on a project, is the be-all and end-all of the decision of the determination of disputes, and that ultimately everybody will call on the same pool of insurance, make sure that that's actually what the contract says. Here, the judge had acknowledged in the first instance decision that the parties gave good evidence that they intended for there to be that sort of arrangement in place, but it wasn't reflected in the terms of the contract. And at the Court of Appeal stage, Justice Coulson, the construction law guru that he is, determined that he wasn't going to accept previous negotiating positions as a way to interpret the contract, given everybody signed it. So the moral of the story is make sure your contract reflects what you thought it was going to. Next slide, please. So then we come on to the case which Katrina mentioned earlier. It's a case with a really, really simple outcome. If your contract says a day, it means the whole day. If you want it to mean by a working day, by a particular time in the day, it needs to say that. Again, this is just a matter of understanding that your contract will mean what it says in most cases. So if you want it to mean something in particular, make sure it does actually say that. I think that brings me to the end of our sort of case law update for now. I'm conscious that we've had a few questions through and we're getting towards the end of the day. So I will hand over to Stefan again to take us through the question section.
Thanks very much, John. Thanks to all of our speakers for those interesting insights. And yeah, as John says, we've had some questions coming in. So the panelists you can see have all rejoined us now. So I will look through some of these questions and go through some of these. So Katrina, probably a question for you to start with. So you mentioned that if the payment provisions in your contract do not comply with the Act, the scheme for construction contracts will imply terms. Does this mean you can no longer rely on the payment provisions in your contract and that the scheme applies instead? We had a few questions along similar lines, actually, but let us know what you think.
Thank you. Well, the scheme won't apply as a wholesale replacement, but it will simply just plug the deficiencies. So if there is an element of your payment process that doesn't comply, so for example, if you specify that you'll serve the payment notice 3 days after the due date for payment, then the scheme will imply that that needs to be served 5 days after the due date for payment. So it plugs the deficiencies as opposed to completely disregarding terms that have been agreed.
Okay, thank you. Richard, question for you here about programs. So how important is a robust program if being used for delay analysis purposes?
Good question. As I said when I was briefly speaking, the important aspect is certainly if it's a dynamic method of analysis, i.e. it is going to undertake reschedule calculations through the software, then the program itself must be robust. It must obviously be robust in the network logic that it has, and it must be relatively robust in terms of reality checks against what is actually going to be happening in the future as you seek to determine what the likely impact may be. A good start point, as I say, is that CRB protocol to review to make sure or give guidance on the level of robustness of the program. Often these things, just to repeat, are built into software so people can do their own checks on how robust a program is, and if they need to, seek some advice from somebody like myself as an expert in the programming world.
Very good, thank you. There's a question here from a structural engineering subcontractor. I'm happy to have first pass at this, but John and Richard, you might have some thoughts as well. Feel free to jump in afterwards. So with the enactment of the, bear with me, sorry, Building Safety Act, there may be more pre-construction services agreements issued for design development. How can cause and effect be measured if there are changes during this design and the design development overruns? Immediate response is it's design development. Is there a clear definition of design development? There are many different answers to what is design development. Yeah, it's an interesting one. Thank you for that question. So as construction lawyers, we often see those provisions, particularly in bespoke forms of contract or amended industry standard forms, where, say, for example, you've got a main contractor who's tendering to a subcontractor, and it's got some fairly extensive amendments, and very often you'll see that phrase, design development. I'm sure that's familiar to lots of the audience, and it very often has a very, very long-winded and wide-ranging definition, and that's for a very good reason from the main contractor's point of view, is that, you know, if they want the subcontractor to be obliged to participate in what can sometimes be quite an undefined design development process that can actually take quite a long time and involve lots of additional effort without having to necessarily give additional time or pay in addition to the subcontract price for that, then clearly that sort of mechanism is going to put the main contractor in a strong position. And it's a real conundrum. You know, we see that a lot in forms of subcontract, and quite often the bargaining positions are such that, you know, a subcontractor might not necessarily be in a position to be able to, you know, negotiate that away. And, you know, in fairness to main contractors, quite often they're only passing down an obligation that's been placed on them under the main contract. So it sometimes does sort of derive itself from upstream from a client as well. So difficult to give a very, you know, specific answer to that, other than to acknowledge the fact that yes, it is an issue, and the best you can do is to try and sort of narrow. I think trying to get it removed completely is probably not a runner, but trying to narrow that scope of what design development means in the contract is probably the best achievable position, I think.
I would definitely agree with that, Stefan. I mean, ultimately, it's knowing what you've agreed as well. Often we see these situations in a dispute type situation where parties haven't necessarily realised that that's what the contract provided, and that the scope of design development was as wide as it is. I think going into it with your eyes open is very important.
Yeah, absolutely. Thanks, John. Okay,
so the
go on, Richard.
I would just say, you know, certainly from a record perspective, if you have a program that has drawn out your design fabrication leading to start of construction for particular activities, then the cause and effect can be used to essentially growth on the activity of the design itself, and then what that rescheduled position would be constraining or impacting the follow-on successor tasks. You would be, in the very least, keeping the records to support what is actually happening. And then you may need the advice of Stefan or John as to whether or not that would likely lead to entitlement on your behalf under the terms of the contract and the definition of design development.
Very good, thank you, Rich. Okay, we're at 12 o'clock, but I'll quickly rattle through a couple more just before we finish. Katrina, back to you if I may. Can I issue payment notices and applications for payment by email?
Thank you. Yes, we get asked this a lot, really, and it goes back to what John says about knowing what your contract says. So if your contract provides for service of notices via email, then absolutely you can serve payment notices or pay less notices or applications by email. You must follow what the contract says.
Okay, thank you. All right, time just for one more then before we finish. Come back to you, John. Question about multiple adjudications. So you said that regarding the HS Works case, multiple adjudications may not be the best way to achieve resolution when there are multiple disputes between the parties. What would you suggest instead? What would you consider when deciding which approach to take?
Yeah, it is always in the balance when we're deciding what the best mechanism is to resolve these disputes, potentially if you're the referring party anyway. Referring multiple adjudications can be a valid tactic, and it can work. it can narrow the issues in a sort of structured way. That means maybe you end up with a settlement sooner rather than later. Doesn't always work though. Often we need to factor in whether it's going to be quicker and cheaper to go down the court route straight away, or if you've got an arbitration clause, to look at maybe a short form arbitration on certain points, which might then narrow the issues between the parties to enable them to reach a settlement sooner rather than later. And with arbitration, sometimes you can be a bit more flexible about that, and you end up with almost a hybrid model between the adjudication regime and the full court regime that might get you some way towards resolving issues more quickly. But ultimately, it is always a horses for courses type decision, and sometimes you need to go down the more tortuous route if that's what's required by the circumstances.
Understood. Very good. Thank you, John. Okay, well, that's just about all we've got time for. We've slightly overrun, but we're very close to keeping to midday. So thank you all very much to our panel. Thank you to the audience for joining us. I hope you found this morning's session informative. When the session ends, you'll be invited to submit your feedback on this morning, and that includes an opportunity to give us suggestions for things that you want to hear about in future. So please do, if you have a moment, take advantage of that and complete the exercise. We always find it very helpful to hear from the audience about other things that they want us to cover on future sessions. On that note, we'll be back in the autumn for the next of our quarterly webinars, so please look out for details of that through the usual platforms, including LinkedIn and so on. All that remains is for me to say thank you once again for joining us. Have a good day, and we very much hope you can join us next time.